Hi, and welcome to this latest immigration law update video. This is the third in my series going through the upper tribunal decisions for 2020, and I've been doing them a month at a time. So this video, we're going to look at the decisions for March 2020. And on Bailey, there are 6 reported decisions. It's going to look at deprivation of citizenship appeals, evidence of church members in conversion cases, the role and duties of a judge in an appeal. So lots of issues to look at this month. What I'm going to do, I'll put the citations for the cases below this video in the YouTube description. I'll also put my slides, which contain the full head notes, on the Number 8 Chambers website. So the first case is Ammari, and that's an EEA appeal, and it's to do with the abandonment issue. Now, in this case, the appellant had applied for a permanent right of residence under the 2016 EEA regulations. He'd previously had a residence card, then he had a retained right of residence, and now he was applying for a permanent right of residence. That was refused by the Secretary of State, and he appealed, and while he was waiting for the appeal, he applied under the settlement scheme and was granted settled status, indefinite leave to remain under the settlement scheme. His appeal came before the immigration judge, and the issue of his settled status didn't come up. The judge dismissed his appeal on the basis he hadn't shown that his ex-wife had been a qualified person. He appealed to the upper tribunal, and in the upper tribunal, the Home Office raised for the first time the fact that he'd been granted leave under the settlement scheme, and they argued that his appeal should therefore be treated as abandoned. Well, time was given for proper argument to be made on that issue, and actually by the time it got to the final appeal, the Home Office conceded the point and actually conceded that the grant of settled status didn't mean his appeal was abandoned, and actually his appeal should be allowed outright. Let's deal with that last bit first. His appeal was allowed outright because he'd obviously had that period of retained rights when he stepped into the shoes of the qualified person, and the judge hadn't considered that, and that qualified him for permanent right of residence. In terms of the abandonment point, the tribunal look at the provisions of the EEA regulations and the previous regulations. Previously, you could appeal under Section 82 of the 2002 Act, and one of the grounds was that it breached your rights under the EU treaties. But now the only ground of appeal is under the regulations, and under the 2016 regulations, you bring your appeal under Regulation 36. And there is no provision within the regulations for the appeals to be treated as abandoned if you're granted a right to reside or leave to remain in the United Kingdom. So Section 104 of the 2002 Act does not apply. So in this case, the grant of indefinite leave to remain under the settlement scheme did not mean that his appeal under the regulations was abandoned. The upper tribunal at paragraph 41 say, well, you might think he actually had already got what he wanted for, but the rights under the settlement scheme are rights under the immigration rules, where he was entitled to pursue his claim under the regulations for an EU law right, which might give him additional protections. So that's why he might want to pursue that. So his appeal wasn't abandoned, and his appeal was ultimately allowed outright. So that's a helpful decision there. Hysaj, forgive my pronunciation, is a deprivation of citizenship case. In this case, Hysaj had come to the United Kingdom. He's an Albanian national, but he claimed to be Kosovan, and he'd also claimed to be an unaccompanied minor. He'd been granted leave to remain, got indefinite leave to remain, and then was naturalized as a British citizen. He applied for entry clearance for his wife to come over from Albania, and at that point, his fraud was discovered, and he accepted that he'd given fraudulent details. In the meantime, he was sentenced to 5 years imprisonment for, I think, GBH, and the Home Office issued initially against him a nullity decision, not deprivation not a deprivation decision. And that led to the case going all the way to the Supreme Court. And you'll see the citation there in the paragraph 1 of the head note, where the Supreme Court found, and it was a decision by consent in the end in the Supreme Court, that the Secretary of State was wrong to issue nullity proceedings against him. So then started again, the Secretary of State issued deprivation proceedings against him. That led to his appeal, and his appeal was unsuccessful, and he appealed to the upper tribunal. The decision is useful because at paragraphs 25 to 38, the upper tribunal summarised the law in relation to deprivation appeals under section 40A, and it's worth looking at that because it concisely summarises the law and the approach, and how, first the judge should look if there's been fraud, then secondly there's a consideration of the discretionary element, and if Article 8 would be breached by the consequences of deprivation, your appeal should be allowed. But even if Article 8 wouldn't be breached, the discretion still has to be looked at. A lot of the argument in this appeal probably won't apply in your cases because it concerns the sort of delay by the Secretary of State because they initially unlawfully made a nullity decision. And the upper tribunal find that the Secretary of State didn't act unlawfully in this case because they followed the law as they understood it at the time. There was no legitimate expectation to be able to benefit from a historic policy, because previously the Secretary of State, up to 2014, as you'll see from Head Note 4, had a policy for those who'd been in the UK for 14 years, and they would normally avoid deprivation, but that was broken by a period of imprisonment, and there wasn't a historic injustice in this case. Look at paragraph 6. On deprivation of British citizenship, there's no automatic revival of the previous indefinite leave to remain. So when you are deprived of your British citizenship, you don't revert back to your indefinite leave to remain. And in terms of proportionality balance, it says there's a heavy weight to be placed on the public interest in maintaining the integrity of the system by which foreign nationals are naturalised and permitted to enjoy the benefits of British citizenship. Any effect on day-to-day life that may result from a person being deprived of British citizenship is a consequence of that person's fraud or deception, and without more cannot tip the proportionality balance so as to compel the respondent to grant a period of leave, whether short or otherwise. Mansoor is another one of the 3225 tax discrepancy cases. This is a judicial review application because what happened in this case, the appellant was refused indefinite leave to remain on long residence grounds under 276B, it was refused under 3225, and had an appeal before the first-year tribunal. The first-year tribunal found that he had practiced deception in this case and made an assessment of his evidence, but nonetheless allowed the appeal on Article 8 grounds because he had a British son. The Secretary of State responded to that by granting him a period of limited, I think 30 months leave to remain. That was challenged by judicial review on the basis that the argument that he should have been granted indefinite leave, not 30 months. After the first-year tribunal hearing, the decision in Balajagari had come out. The upper tribunal in the judicial review and Judge Allen finds that the decision is not unlawful and refuses the judicial review application. And he finds one of the main points in Balajagari is that the Secretary of State was routinely depriving people of an opportunity for giving an explanation before a decision was reached on their claim. But in this case, there was an appeal. And in an appeal, there's an opportunity to put your full explanation and have the independent judiciary assess that. So the point in Balajagari is rendered immaterial in cases where you have a statutory right of appeal. Case of MH. MH has two elements to it. The first thing is about witnesses from the church in a conversion case. And the second issue is the review and slip rule powers of the tribunal. Let's put this in some context. The appellant's appeal, He appealed on the basis of his conversion. A witness from a church had come along. This was a senior church member who was, in fact, I think, a hospital doctor. The judge had rejected the credibility of the appellant's evidence and also rejected the evidence of the witness from the church. The judge's reasons for rejecting the evidence from the witness of the church was that the witness had given evidence in one of these sort of cases before and didn't know the outcome of that case and hadn't asked that appellant. Now, the judge rejected the evidence, but actually at the notice of decision at the bottom of the decision, it said, I allow the appeal on asylum grounds, which was clearly an error. So the Secretary of State appealed and the appellant appealed. Both were granted permission. Dealing with the Secretary of State's issue first, the upper tribunal look at part 4 of the first tier tribunal procedure rules, which gives a toolkit of powers. And really, the aim of these is to save time and expense and to further the overriding objective of doing justice. So if there's an obvious error in a determination, a judge shouldn't grant permission to appeal, but can use their powers of review under Rule 35. And also there's the slip rule in Rule 31. Now, in a previous upper tribunal case of Katsonga, you'll see it in 3 of the head note, the upper tribunal had held that the slip rule didn't apply where the correction would change the outcome of the appeal. But the upper tribunal, following AS Afghanistan in the Court of Appeal, held that Katsonga should not be followed and the slip rule could be used in this sort of case. And actually they look at Rule 36. Rule 36 allows you and allows the tribunal to treat an application and for permission to appeal as a application under the slip rule or vice versa, or an application for review. So it gives some flexibility in considering these matters. In terms of the other point, the evidence by the church witnesses, they found the judge's reasoning in this case irrational, and they found that the judge's alternative basis for dismissing the appeal couldn't stand. Now, they make the point at paragraph 35 that they didn't hear full argument on the sort of case law, and particularly the Scottish case of TF and MA, yet they go on to give a reported decision on this and give guidance in the head note and in the substance of the decision. Because in the Scottish case of TF and MA, the Lord Glennie, I think it was, there in the Court of Session had said that evidence of church witnesses could be characterised as expert evidence. Now, the upper tribunal held that was obiter. It wasn't part of the ratio of the decision. The ratio of TF and MA is that the judge shouldn't have rejected the conversion account because of the credibility of the other aspect of the asylum claim. That was the ratio. But in terms of the point about whether it was expert evidence, the upper tribunal said, look, such evidence is not properly categorized as expert evidence, and they look at case law and practice directions in relation to that. And nor is it deserving of a particular weight. It's a matter for the judicial fact finder, although it is potentially significant evidence, and it was significant in this case, such to overturn and the case and needing it to be reheard and reconsidered. So have a look at that if you're dealing with conversion cases. But the position of the upper tribunal is evidence from church witnesses shouldn't be categorized as expert evidence. What about the role and duties of a judge? Well, in WA, an Egyptian asylum claim, some issues had come up during the appellant's cross-examination where he was being questioned on a sort of aspect of his claim that he hadn't previously disclosed. And the judge ended up adjourning the appeal for a further statement to be taken. It seems that it was of the judge's own initiative. And the upper tribunal found that this was wrong and a procedural error. And they say, look, during the taking of evidence, a judge's role is merely supervisory. And they set out at paragraph 6, and it's worth having a look at paragraph 6 of this case in terms of what a judge's role is during a hearing. Because if a judge does cross the line and enter into an arena and you need to appeal that decision, you may be able to use paragraph 6 of WA. And at head note 2, they say if something happens during a hearing that disrupts the normal course of taking evidence, it is essential that the judge records what happened and why, who said what and what decision the judge made and on what basis. Have a look at paragraph 7 of the decision in relation to that. And it's important, actually, when these procedural issues come up in hearings, that you as an advocate take a verbatim note and a clear, precise note of what happens, because it may be that you have to do a witness statement and have to step back from being the advocate in the upper tribunal. The upper tribunal also find that there weren't adequate and proper reasoning in this case to clearly see why the judge had made the decision he had, so set aside the decision in its entirety. The final case I want to look at is the case of Younas. It's a case that looks at sort of children, Chikwamba, section 117b6, and Zambrano. I've talked about it in a number of other videos and training sessions. It's a troubling decision, and hopefully will be challenged to the Court of Appeal, either in this case or in another case. It involves Mrs. Younas, a Pakistani national who'd lived her life in the United Arab Emirates. She came to the United Kingdom on a visit visa while pregnant to visit her partner. He had 2 British children by another relationship. Subsequently, their child was born in the United Kingdom. She made an application for leave to remain. That failed and the appeal was dismissed. An appeal was lodged to the upper tribunal. And in the upper tribunal, the Secretary of State accepted there were insurmountable obstacles to the family life continuing outside the UK, and it would not be reasonable or proportionate to separate the family indefinitely. And hold on to that for a minute. The upper tribunal found against Mrs. Younas on credibility grounds. They found that she'd not been truthful about her level of ties back in Pakistan, and also not been truthful about whether her husband could meet the financial requirements if an application for entry clearance had to be made. And they found that if an application for entry clearance was made, that the entry clearance requirements and the financial requirements there would be met, and that would only take 4 to 9 months to resolve. And while she would therefore meet the entry clearance requirements and the Chikwamba principle was engaged, they found that her immigration history, her credibility, the fact she entered as a visitor, weighed against her, such to outweigh the Chikwamba argument in this case. And they say at paragraph 1 of the headnote, an appellant in an Article 8 human rights appeal who argues that there is no public interest in removal because after leaving the UK, he or she will be granted entry clearance, must in all cases address the relevant considerations in Part 5A of the Nationality, Immigration and Asylum Act 2002, including section 117b1, which stipulates that the maintenance of effective immigration controls is in the public interest. Reliance on Chikwamba does not obviate the need to do this. So what they're saying is, even if you meet the Chikwamba argument, and note, you've got to show that you can meet the entry clearance requirements for Chikwamba to bite, your immigration history and the public interest may still outweigh that. Now, I'm slightly troubled by that because the statements about Chikwamba in previous cases has talked about there being no public interest. And whilst section 11C factors, you have to have regard to them, there still has to be this proper consideration. So I am troubled by that, but this is going to be the approach of the tribunal while Younas remains good law. As I said, they found that entry clearance would take 4 to 9 months. And so they said, well, section 117b6 requires the tribunal to assume that the child will leave. It's a hypothetical question. But then in assessing reasonableness, we move from the hypothetical to the real, citing KO Nigeria in the second part of the headnote there. And the length of the time the child will be outside of the UK is relevant to the reasonableness consideration. So they found in this case, it was reasonable given that the child would only be outside the UK for 4 to 9 months. Although, in my view, that's quite speculative because one doesn't know how long, and entry clearance applications often take much longer than we first expect. But they found in this case, it was not unreasonable. And this real world assessment of reasonableness includes how long somebody's likely to be out of the UK. And in terms of the Zambrano argument, that compelling the child to leave would deprive him or her of the genuine enjoyment of their rights as a British citizen, well, that has to be looked at on the actual facts. And given the child is not going to be outside the UK for a significant period of time, although in a young child's life, 4 to 9 months could be a very significant period, it didn't deprive them of their genuine enjoyment of their rights as a British citizen, so they rejected the Zambrano argument. So a very difficult case. In previous videos, I've talked about the Court of Appeal decision in Runa. That's a more positive decision in terms of 117b6. Have a look at that. But that's a troubling decision, Younas, but you need to be aware of it and be able to distinguish your client's immigration history when assessing the public interest. So those are the reported decisions for March 2020. As I said, I'll put the links below this video and I'll put my slides on the Number 8 Chambers website. I hope that's helpful to you, and I look forward to the next video where we'll look at April. I don't think there's that many decisions in April, so it might be a quick video, but we'll see you soon.